Okay, so we are live streaming, and as previously explained, Judge Baio was unable to attend today, but we are still going to go forward with the meeting. So I'm going to just do a quick attendance in no particular order, just as everyone is appearing on the screen. We have Judge Spader, Attorney Pocklington, Attorney Generis, Judge Aldomat, Attorney Gentis, Attorney Sternberg, Attorney Salato, and Judge Rohraback with us today. So that being said, I'm going to call the meeting to order. Probably should have done that the other way around, but here we are. And the first item we have up is the approval of the minutes of January 29th, 2025 meeting with the corrections that were previously discussed. Does anybody want to discuss that at all any further?
I just have to abstain from voting on it because I was not present at that meeting.
Thank you, Your Honor. Is there a motion to approve?
So moved.
Thank you. And do we have a second?
I'll second it.
Thank you. Any further discussion? Okay. All in favor?
Aye.
Thank you. Any other abstentions besides?
I'm embarrassed not to remember whether I was there in January or not. I can't remember what I heard at 9:30 this morning. Let alone what
Your Honor, I think you were excused, if I recall correctly.
No, he was there. I was the one that was excused.
You were excused, okay.
All right, thank you. Then I'll abstain from approving the minutes.
Okay, so the vote carries. Moving on to our old business, Judge Baio just asked that I give you an update on our outstanding recommendations that were made to judicial and adopted by judicial with Judge Bellis's support on the motions to substitute that went into effect with the clerk's offices in mid-March is when court operations informed them all of the uniform procedure that should be followed for motions to substitute plaintiff in all civil cases, including foreclosures. I know that implementation is usually bumpy for us, getting all of the clerk's offices to turn over. Some were doing the process or pretty close to the process to begin with, while others are completely changing the way they process motions to substitute. So I would ask that you be patient, but if you are in a district and you're practicing and you notice that that procedure is not being followed in terms of substituting the correct plaintiff and then removing the first plaintiff so that there won't be any notices generated, just shoot me an email or give me a call and let me know, and we'll follow up with those offices. We're spot checking, but we do give them a little bit of a grace period because it is a big change for some of the clerk's offices. Any questions on that one?
So this happened to me twice in Bridgeport, where what's happening is they substituted the plaintiff, but they took out my appearance. So it looks like the plaintiff is not appearing. So I was receiving no court notices for those cases because, and I don't know if that was just like a glitch in these like two random cases, but it's like almost going to be impossible, I guess, to track, because I don't know at what point the system changes over that there's no appearance for the plaintiff at all.
So they, are you appearing for the substituted plaintiff as well?
No.
But your intention is to, when you're doing the motion to substitute?
Yeah.
They should be adding your juris number. I think it's practice for most of plaintiffs' firms to include the appearance of the juris number that they want of record for the substituted party. So I can certainly speak to Bridgeport and whomever's processing those just to make sure that they're following through with that extra piece. That is part of the uniform procedure, that they should be pulling the juris number.
Had to with the first case, I was like, did I screw up on this case? Like I missed a court notice, and then it happened again, and I'm like, wait a minute, it says non-appearing. So I had to like actually hit e-file an appearance and file it like a new appearance.
You shouldn't have to do that with your foreclosures.
Okay.
As long as you,
I wasn't sure.
as long as your appearance is included in the motion to substitute and you are intending to substitute for that new plaintiff, they should be adding your appearance. So Again, if anything like that happens, let me know. We'll just do a follow-up with whichever clerk's office it is to make sure that they're aware of the issue and that they're following the new procedures that we've outlined.
Okay. And it could have been a fluke. It was just 2 cases.
Yeah,
Yeah.
it's, well, 2 times
never
is usually not a fluke for us, so
Okay.
we'll make
But
sure.
again, but that's why as a judicial branch, we even have this committee. It's like you guys are the ears on the ground, Attorney Pockington, Generis, Gentis, everybody. So this happened to you, but if you are talking to some of your colleagues and they say what's happening, that helps us have the feedback to make sure that what we're doing in the clerk's offices are being implemented to, because if it happened to you, it's probably happened to someone else too, but when you hear about those things, please let us know.
Absolutely. Okay, anything further on the motions to substitute? Okay, the timing of supplemental judgment, I do extend our apologies on this one. The recommendation was adopted and the update is being made to the JDCV. I believe it's the 79. Was the insertion of the sentence that I think Attorney Generis had drafted for us, and that was approved. It is with legal. It's my understanding it's in the final stages of being implemented on that form, and I expect it to be posted shortly. So I will email everyone once that is posted to the branch's website, and on our end, as part of the implementation from court operations, we'll be notifying our clerks of the update to that form standing order so that they know. And then Judge Bellis also sends out information to the judges so that they're aware as well that it's been posted. So that should happen hopefully in short order. I was hoping they would have it up before today, but it's not to be. Any questions on that one? Okay, moving on. We had a very lengthy discussion last time we met on holding sales at the property, and it went over as old business to this meeting. We hadn't really come to any sort of consensus as to whether or not there was a recommendation that we wanted to make and wanted to have further discussions on it. So I know originally, I think Attorney Gentis, this was your proposed topic, but there was a lot of conversation regarding it. So
yeah, and I think it could be 2 different things. It could be, one is the question of whether to post a sign on the property, and I took Attorney Pocklington's, it was he didn't have a lot of time to prepare, but I thought his suggestion was a good one, so I'm not holding him to it, of splitting between non-appearing parties, putting a sign in those instances and not putting a sign when the party appears. So that might be a way to move forward on that aspect of it. And then the second piece is just the practice of holding a judicial sale at the property. If that were something that were at least, and the background for Judge Spader is that Connecticut is stunningly unusual in its degree of frankly humiliation that it puts homeowners through in terms of where it conducts their foreclosures and the signs that it advertises those foreclosures. And I say that amongst the 50 states. But perhaps we could bifurcate the discussion and just talk about the first part about putting the sign on the property and making a non-appearing versus appearing parties distinction.
sure. Does anyone else want to be heard on the matter of signs at the property? We did have a very lengthy conversation about concerns about notice for the non-appearing. I don't know, Attorney Pocklington, did you want to speak to that again?
I just to, in short, just sort of reiterate where we last were, that the number of homeowners that I've had have filed motions to open or reach out to my office for the first time based off the sign going up is significant enough that I'm concerned about getting rid of them entirely. Whether it's appropriate to have them, so from my perspective, the sign serves 2 useful purposes: notifying the homeowner as one last ditch effort, and also notifying the public of the availability of the property for sale. I think Attorney Gentis's concerns are more directed at the second than the first, based off comments about the humiliating nature of foreclosure proceedings and whatnot. I don't know whether drawing the line, there are a couple of places where a line could be drawn where the first benefit is still obtained in terms of notice to a homeowner while minimizing the second variable, and having them be only necessary in the case of an appearing part, or rather only in the case of a non-appearing homeowner is definitely an option. The other thing could just be giving a clear standing order carve out. Obviously, the court has authority. Judges waive signs on a regular basis. They're already waived universally for condos, but just giving a bit more of a standing order approval that the sign, can be waived upon request, and putting the all, because what I am concerned about in terms of the just waiving it across the board with all appearing defendants is that a defendant should have the option to maximize the sale proceeds, which means getting the news of the sale out as far as possible, et cetera. So there is a potential, I don't want to call it a chilling impact, but there is the theoretical possibility of removing signs in general, decreasing attendance at sales. But if if a homeowner doesn't want a sign, I don't see how it helps to have one, but maybe the onus should be on the homeowner to request that there be no sign. I'm not sure quite where to draw that line. And that's something I would invite discussion on.
Our issue there is anytime, I mean, homeowners still have the notice of unemployment, or they have the right to seek like the unemployment relief, but they don't because there's no notice anymore, right? Without the notice of the right to waive your sign, I don't know that they're going to exercise it. And then the second part is just in terms of like, yes, there might be, the scattered person who finds out about a sale because of a sign, and then they win or bid a property up. The issue is just we just don't have the data in Connecticut showing that somehow we're doing a better job yielding value on foreclosure sales compared to other states. It's just not there.
Do we track what percentage of the successful bidders are the plaintiffs when we have sales?
It was as of, it's 2/3 more or less. It's gotten a little bit different in the past year or two because of the extremely low supply of homes available. So third-party bidders are above where they've been, and then you actually have real equity now. But that number is not that much different than other states that just do foreclosure sales by default. Even in those circumstances, in those states, which is essentially almost every other state without strict foreclosure, they're not seeing a huge difference in the number of plaintiffs that win those auctions either. So
yeah, but that may
it's
be
still.
I don't necessarily know that we want to be looking at data and in this particular niche comparing us to other states, because when you think about sales where the plaintiff is the high bidder, if sale is the only option, that means anyone that's underwater would be a plaintiff high bidder. It's sort of in the same manner where U.S. sales because the U.S. is a party versus because sales where there is actual equity. Plaintiff's almost always going to be the high bidder in a U.S. sale. So the existence of strict foreclosure kind of, I suspect, skews those numbers in terms of comparing how many of our sales go plaintiff versus how many of other judicial states with, how the percentage of those that go plaintiff sale. You have to take into account all the ones that were they in Connecticut would have been strict.
So under that rationale, I know what you're saying. A strict foreclosure option would create, our numbers would be higher, right? They should be substantially higher of third-party bidders, right? Because you don't have all those negative equity. You have fewer negative equity properties going to sale because instead they're going by strict. So there in turn would have, lower plaintiff bids relative to a higher fair market value. And we really don't have that many, that our numbers just aren't that different. I know it's weird, but there's all these I guess what like the long and short of it is people have been tinkering with foreclosure sales for 200 years, and they really the sort of law and economics approaches to it just don't bear out for whatever reason. And so I'm looking at it from, if the economics of it are negligible, let's just have fewer signs.
I mean, I can only kind of speak from what I see. And when you're reviewing a number of the committee reports, and I've reviewed hundreds of them over the past few years, you see generally the same bidders and the same contact people. People are finding out about the auctions largely from the judicial branch website, not from driving around looking for properties. Oh, there's a sign up on this one. However, Attorney Poppington's point is also extremely relevant, because a lot of times the first contact that we'll get, people ignore what they get served for the marshal, but that sign does cause a reality. So it is very, I think, important that those signs go up. And I think the attorneys who are on this call can probably say they've seen me a lot of times just, all right, I want that sign to go up even earlier before there's more committee fees and costs, just trying to get attention while we can still work with the person, which is kind of like opposite of what you want. Attorney Gentis is like even an earlier sign, but sometimes that's the thing that brings the reality and gets someone into the courthouse to try to save their property, which a lot of times, the plaintiffs don't even really want a lot of these properties. They just want to get paid. So, they want to work with someone trying to get people to address the situation. I do like, if there is any thought of getting rid of signs, I do think signs do have a benefit to the non-appearing party. Could it be one of the questions that we ask all judges to ask at the foreclosure hearing? We ask, okay, do you have an appraisal? Do you have the debt? What is the defendant's position on a sign? How much is that really to add to the, foreclosure hearing? It's a second, so they are on notice of the ability to ask for no sign. I waive signs quite frequently because I think it's not a valid. I think it's an expense that's an extra $300 out the door. With the U.S. as a party, no one's going to be bidding on this besides a plaintiff on a lot of actions. But nonetheless, I think there is a benefit to it in the non-appearing situation.
To address Attorney Jensen's concern that even if there is an option to request no sign, most of the homeowners might not know about it. Could we incorporate that into the orders that go out, perhaps on entry of judgment? The appearing parties, or some sort of statement goes out. The court's available to hear a request that a sign not be posted, but absent a request in that regard, the committee will post a sign in approximately 3 weeks. So we could just sort of give them one last nudge that if you don't want a sign, let us know. And or do you think that just puts an extra step in and makes it even more complicated?
My sense is I appreciate that. My sense is that I think if you have someone showing up in court and you ask them, do you want to sign? And they say yes, then sure. The people who have appeared and then don't show up for the judgment hearing are by and large, a lot of them have tried and are moving on. And I also I hear what everybody's saying, but the number where we see where someone was provoked by a sign into doing something and then kept the house. I'm not talking about then got a little more time, but then actually kept the house, is pretty small for us. I mean, I hear you, but I hear what everybody's saying, and I realize everyone's got higher numbers than I do, but I still have talked to 13,000 people. So we have a decent sense of their feelings. And, but yeah, in other words, maybe it's just tweaking it so that the default is opting into a sign for appearing parties as opposed to having them opt out. And I don't know too, the other thing might be that, or you put it on the committee. The committee has to get affirmative consent from a homeowner to put up a sign. Now it's also not done at judgment. Now, granted, you don't have a record in the same way. Guess you
My
could add
concern-
a worksheet.
My concern with that would be that the committee is likely going to charge higher fees in order for trying to reach out to the defendant if they're unable to reach them. We really haven't accomplished anything, but I mean, the committee fees are already pretty high, so requiring them to take additional steps to try to contact a defendant, I don't know if that's economically feasible. I mean, at this point, I understand the current concerns with regards to the sign. I personally gotten calls from defendants who have complained about the sign being placed by the committee, and I understand that some people don't want their neighbors to know what's going on with regards to their own personal information. But I mean, I think there's certainly an option available for defendants to request a waiver of a sign. I don't have any issue with the sign being waived. Like Attorney Pocklington was saying, I'm under the impression that the sign, ultimately, the goal is to benefit the homeowner and trying to get more interest in a sale, get more bidders at a sale. Obviously, it's a situation with where the U.S. is a party, there's no equity. It's obviously not going to accomplish much. And I understand completely waiving signs in that case. But I mean, if a defendant doesn't want to sign, I have no issue with them being able to request a waiver of that sign. But I think erring on the side of caution and not defaulting to having no sign whatsoever, I think would be a better course of action.
Just thinking out loud. Oh, sorry, Judge Rohrbeck, go ahead.
Oh, that's, I mean, so not to take too big a detour, I was at the DMV in Old Saybrook last weekend getting my 16-year-old son his learner's permit. And I walk in and I say, hey, can I get my real ID? And the guy's like, go on your phone. I mean, what do you mean go on your phone? If you want to make it up, you got to make an appointment. I said, but I'm here. Can you give me an appointment? No, I can't. You got to go on your phone to make an appointment to have a thing here. Like, oh my God. So that is apropos of this. What is the sign? Why do we put so much crap on the sign? Why don't we just say, we could modify what the sign says and just say foreclosure sale pending, visit www.blah, blah, 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 blah for more information. That would wake up the homeowner that's got their head up, you know, don't know what's going on. It would lessen potentially the cost of the sign because we could mass produce them. I'm just kind of thinking outside the box of an intermediary. Now, it doesn't take away the embarrassment for your neighbors. So just another, like, put a QR code, whatever. The fact that we put all this information of the name of the committee and call this number and blah, 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 none of that needs to be on the sign. You know, if you're not tech savvy these days, you're not allowed to function in our society.
You're right.
And I know that because I'm not tech savvy and I have resigned from society officially.
But again, you're right, though. That doesn't solve what Attorney Gentis is trying to point out as far as the humanitarian side.
So if there's an appearing defendant, then what the heck, you know, come and when we go to judgment, we'll say, do you want to sign or do you not want to sign? If they say no sign, then there's no sign. But if you're not appearing.
Just as a weird thought, again, maybe this will spark something from another member of the committee, but we've got the perspective on this in terms of how many people would want to sign versus how many wouldn't is a little bit varied. Perhaps maybe it's as simple as the branch has any number, and I know that Becky's going to give me the look of suggesting something, but the branch has any number of sample forms and templates that are used in any number of actions between. I mean, some things are very universally applicable, like case law requests and appearance forms and whatnot. We've all seen the same petition to participate form that's not the official branch JDCV 95, or 96, but gets used everywhere. I'm wondering whether it might make sense to just put out a request for waiver of sign in court service centers. That's an easy, simple thing that a homeowner can say, yeah, I want to do this. I check the box, I sign the form, I fill in my case caption, and it's all that needs to be done to prevent the type of embarrassment and humiliation that Jeff is, or that Attorney Justice is concerned about, just by making it easier for people to opt out as opposed to, I mean, jumping through a bunch of hoops with the rules.
Why don't we serve it with the complaint, with all the other pile of 50 million papers that we serve with the complaint? Why don't we serve that form? And maybe if they see that one, they're like, what? There's going to be a sign? Maybe I better file an appearance.
Because they don't read it all right now as it is.
But you know.
That is a constant critique that we get in terms of like all of the paperwork that gets served for FMP. Just speaking to James' suggestion, forms, they take a little bit of time for judicial because they do go through legal before they get printed, but we do forms every day. So if the committee's recommendation was, to do a form, and Judge Bellis was supportive of that, we would do a form. I don't think it would be a very difficult form. And I do know that the preference would be that we have a form with an official form number and all of that jazz and a docket legend and everything, so that a queues and a process that we would develop and send to the clerk so that they would know what to do with it. Anything that we put in the court service center, the preference these days would be that it be an official judicial publication, because that way we can track it. And if there's a change in statute or procedure, we can modify it as needed. So I don't love making all of the forms, James, but for you, we could certainly, Attorney Pocklington, we could certainly accomplish that. It doesn't sound like it would be a heavy lift in terms of substance.
Just in terms of sort of moving the conversation along, are we all at least on the same page that signs for non-appearing parties are probably, a good element of the safety net? I know it's very weird to me. I know we're being live streamed, but I'm feeling the weird in terms of I'm advocating for things to protect homeowners, whereas Jeff is, at least from my perspective, advocating for things that might allow somebody to, take one less opportunity for notice. But are we at least on the same page that the sign does have a useful purpose in that regard for non-appearing homeowners?
I was waiting
I'd
for
agree with
Jeff's
you.
unmute to go off.
Sorry, I got some announcements happening, and I'm gonna just turn into a pumpkin shortly. But yeah, I mean, look, in terms of moving the conversation along, I think I'm fine with some kind of. I would prefer an opt-in to a sign. And you could file a form that says you'd opting into having a sign. It really, I mean, the other thing is, it's not just for the actual homeowners, it's for what other people think the foreclosure process involves when they're in foreclosure too. That's where the questions are coming from. People are asking us, not just there's a sign in my yard, this is awful, but will I get a sign? So it's beyond, and again, the impact is anecdotal and not statistically significant about it actually doing something. So, and I talked to somebody, I can say it now because the case got withdrawn. I talked to somebody a few months ago who said they were provoked into action. So I get it, it exists.
Or even not even just being made aware. So Attorney Gentis, the risk of no sign is that instead of the homeowner being woken up by the sign, they're not woken up until someone arrives with eviction papers saying, "Oh, your house has been sold." They're like, "What?
Right.
What do you mean? No one ever told me."
Yeah, it happens. Yeah, I hear you. No, and I look, we're the other, and some of this is it is really hard to separate all of our individual experiences from like the collective, right? And because we can all come up, because we're lawyers, right? The one thing we can do is, what about, right? But I hear you, and I know it exists. But heck, anything that would get us towards fewer signs is a positive. So however we do that, with like you opt in, you opt out, we put a form right at the beginning so that if at any point you want to file that on the court record prior to judgment, prior to the committee, prior to the bar date,
literally no one would
great.
opt in. Literally no one would opt in. But again, I think for some sort of extra due process level, there is some benefit to having a sign there in the non-appearing cases, at least. just in terms of moving it forward, I do kind of, as much as Becky started to frown when Attorney Pocklington was speaking a little while ago, it wouldn't hurt to have a form that says opt out, at least as an initial matter while the discussion continues on this point.
And
And I
that
think
may
the
be a
consensus
way
of
to
the-
get the data that Jeff is looking for in terms of the committee, just speaking out loud, or thinking out loud, the committee recommends a 2-year pilot wherein this form can be used to opt out of signs, and then we'll be able to gather data about whether the sign requirement is a good idea on a go-forward basis. Or our successors on this committee will be, because some of us may not be here at that point.
Is that a motion?
I don't know. I'm waiting to see if anybody even likes, I even get a smile or a nod before I make it as a motion.
I would ask our interim chair to weigh in on whether a 2-year pilot or just putting the form in place and then later withdrawing it is better administratively.
From an administrative perspective, unless there is just no use for a form, I don't know why we would create one and then remove it, unless there was some sort of rule or case law or something that said you can't file such a thing. I don't think that we would be for creating a form just to remove it. It would need its own docket legend code so that we could track it. What Attorney Pocklington is discussing, which perhaps would inform this committee and Attorney Gentis and gathering data, would be how many, appearing homeowners file a request to opt out of having the sign. We would want to have create its own docket legend so that we could have our statistics unit easily pull that. But again, it's not a heavy lift for court operations, and I don't know that legal will appreciate me speaking on their behalf, but as long as they don't have an issue with the contents of the form from a legal standpoint, it sounds like it would be just a 1-page form, and administratively from FMP mediator standpoint, that is just after we had our last meeting, that is a point of concern for a lot of homeowners who have, kind of reached the end of mediation and it is going to go by sale, and that's the choice that's being made, and the mediator and counsel are talking to them about what's going to happen and what the court process is, and there is concern about the embarrassment of having a sign. That's something then that gives the mediator and counsel an additional tool that the homeowner can use at that time, since it's not required to be filed at short calendar or anything. They can file it during mediation. So again, administratively, I don't think that it would be overly burdensome at all. That being said, have we landed somewhere? It sounded like there was a consensus that the motion would be that the sign for the non-appearing parties would occur, and then some sort of, if we're going the form route, an opt-out method.
I like that.
I like that. And if it turns out that we see a large wave of homeowners electing to opt out at some point in the future, then it becomes why shouldn't this just be the default? So to that end, I am making a motion that we continue, we make no changes as to signs for non-appearing parties. However, we create a process by which an appearing homeowner may elect to request, or may request to opt out of a sign being placed as part of a judgment of foreclosure by sale through a to be drafted judicial form.
Okay. The formal motion.
Yep.
Do we have a second?
I'll second. Hopefully I understood everything that Attorney Pocklington said there, but I will second it.
No further discussion? Okay. All those in favor?
Aye.
Aye.
Okay. Were there any nays? Okay. Unanimously carries then.
Thank you, everybody. I really appreciate it.
The second part of your discussion,
And
Attorney Gentis, was the committee rates. Is that you also?
I don't think
I
we're
guess
there yet. Were we,
Just the
wasn't
second
part two of
part.
this was a location of sales?
Yeah, and I would propose that we table that till July. And in the meantime, I don't know what makes sense in terms of thinking, especially in terms of our plaintiffs' attorneys, to the extent that there would be efficiencies gained from committees conducting perhaps multiple auctions at the courthouse on a particular, all at once, as opposed to the specific part piece by piece. I leave that to you, but it's an idea. Judge Bader, the background is essentially we're one of only 2 states that does this, sales at the property.
I know the
it's just
background on it. We're good.
Crying foreclosures on the courthouse.
I was admitted in
now.
5 states when I was an attorney, so I've been at the New York courthouse auctions and Rhode Island.
Yeah.
I know
So
the various.
that's prime. Everywhere else is sort of a public gathering place. Vermont's like
Does-
at the curb.
But is that a
Courthouse,
statute?
sheriff's office.
Is that a statutory change? No.
No, this is like an idea from the 19th century.
Okay.
It's like our greens. We have lovely greens and we have sales at properties.
So are you also proposing we get rid of all municipal greens?
Based on my experience with litigation over Lebanon Green a few years ago, maybe, but we'll table that. I think that's beyond the purview of the charge of this committee. So, but yeah, no, it's an idea with the same basic things, the same basic ideas, but I'm curious really for how the economics would work. And then, frankly, I don't think there's a charge of judicial of committees meeting on courthouse steps, even if it were a Saturday, but happy to, maybe we could roll it over and come back in 3 months. And I say this partly because I will be boarding soon. We'll miss you folks. I'm way to lovely Long Beach, which is, if you haven't been there, it's like the beaches of South Boston mixed with the downtown of a depressed industrial city that I won't slander anything in Connecticut, but maybe Lowell, Mass. How about that?
The only closing thought I have on that in terms of tabling it, and I'm fine with tabling it, is that I don't know, Becky, if use of the courthouse steps, would have any sort of branch implications in terms of liability insurance, people there, and that type of thing. So there may be things well beyond the scope of the committee that should be taken into account.
Attorney Pocklington certainly cannot speak to what that is, but I also share the concerns about, legal's view on that and liability to have people on judicial property, whether or not there's an increase in that. So again, happy to table it. We can talk about it at the next meeting. And if a recommendation does come out of this committee and there are those concerns, I'm sure they will go well beyond me to be vetted and reviewed. So we'll table that. Perfect. Thank you, everyone. Moving on to new business. I know Attorney Gentis is going to be leaving us shortly, but the committee rates came out of that.
Plane's broken. It'll be delayed.
Okay,
Sorry.
I'm sorry for you that the plane is that stinks.
Bad news for everyone here, including
So
the other attendees in this meeting.
So you're saying we could have had the trial that I scheduled here in this courtroom earlier this morning that we continued because your flight's not leaving after all.
But we can have very robust committee rates.
Plaintiff's counsel was unavailable for that as well. I know you thought I might be available for it, but I got you.
Okay, so new business committee rates came out of the discussion, the overall discussion about holding sales at the property. It came up in terms of what rates and different rates being, charged throughout the state. I know that just as a kind of recap, that I believe Judge Altermat had looked at some varying rates in his district, and a decision was made that we should create a separate discussion for that, and if there were going to be any uniform recommendations coming out of this committee regarding committee rates.
in a different forum with some of my colleagues. I just bounced off a similar question. I asked them what rates they were usually awarding. And I was actually surprised that the two jurisdictions perhaps nearest to me are Tolland, and I'm up in Putnam, Tolland and then New London, and they were actually lower than what I've traditionally been awarding. And so they thought my rates were high. I thought theirs were low. So and as I may have just thrown out before, obviously we have to determine what's reasonable under the circumstances. I think that's our instructions, but rates were going from 200 to 300 seemed to be what the judges were typically awarding, and there are flyers all over the lot. I mean, some firms are asking more, and I don't think it was in this forum, but one of my colleagues in one of the other discussions I had suggested that we should all remember that although the rates may be lower than what some of the attorneys might wish to get from some of their clients otherwise, this is a situation where you're never going to get stiffed by a client. I mean, it's almost guaranteed money for the hours spent. So maybe there's some discount is warranted. But anyway, I certainly haven't done any further analysis outside of this district. But perhaps some of you folks have a lot more information about that. Or not.
I just thought I'd spoken enough and y'all were sick of hearing my voice. But ultimately, there definitely is a spread. It is in part based off of what's interesting to me from a practitioner perspective, because obviously the amount that the committees get paid, or rather the amount that gets approved for committee payments, isn't something that we really have a proverbial dog in that fight. It's based off what the court feels is reasonable, and then the lenders pay whatever they're told to pay. But what does strike me is that some of those approved committee rates are based off of opinions of judges that aren't necessarily on the bench anymore, that have sort of passed down generationally through different foreclosure clerks and whatnot. And it's always interesting to me to hear where the source of a particular cap comes from. And what I would suggest, that in order to advance this conversation a little bit, is it may be a good idea to take a internal survey. For the most part, most districts have one particular foreclosure judge. Some have one or two. Stanford has the most in its active rotation because of Stanford being Stanford, but ultimately they're pretty much in lockstep in terms of approved in this particular area. So maybe it's a good idea to just get the numbers that are approved in each district, see if they have a reason why that's what they typically approve. And if it turns out that that's old information from several judges ago, and then what I would suggest in terms of actual work from the committee here is that we propose to update the CV 79 form, which is the standing orders for foreclosures by sale. Right now, there's a page 3 addendum to that discusses the newspapers used in each jurisdiction and the publication schedules, and that makes that information that's no longer really all that useful very out there for both the members of the bar and prospective committees, knowing full well statewide with a glance at a form what the committee reimbursement rate is across the board could be very useful information, even if it's not necessarily uniform. But knowing that Bridgeport gets X, Stanford gets Y, Danbury gets Z. I mean, obviously committees can only be committees in the district in which their office is located, so it's not like they have the option to move or shop around without moving, but knowledge is never a bad thing.
And perhaps along with the fees, the typical hours that are justified. I mean, I may have told you last time, but I took a canvass of some of the people that I respect out here, and they told me they thought $275 an hour for about 14 hours was sort of a benchmark. And so I wouldn't want to just know what everybody else's fees were, because it doesn't do any good if somebody's charging 35 hours to do a standard, committee, versus 15 versus 10. So, but that's just a thought.
My thought just regarding polling of clerks and additionally judges would be that maybe some judges would not want to put on the record for this committee where the fee comes from, and perhaps maybe the recommendation could be to for Judge Bayo to recommend to Judge Bellis that a poll be conducted and that Judge Bellis and Judge Bayo inform what the information ask is, and then it could be shared with the committee. I don't think that from an operational standpoint, I would conduct a poll of that nature of judges and their practices without some input from Judge Bellis.
Thank you, Becky. I think that may resolve that issue for now if you want, and we're gonna just to help you move along, as it's 4:20. I know you're looking at the clock getting nervous, so.
No worries. I mean, is that something we would be interested in doing in a formal recommendation? That would be the recommendation for now, that would, if acceptable, inform the rest of the discussion and process going forward?
I would say leave it to Judge Bayo on how best to proceed on that issue.
Okay, I will let her know that the committee is leaving it to her to make, to decide whether or not to make a request and what that request should be of Judge Bellis. Safe to say nothing further then on the committee rates until we have an answer regarding that. And we
Sounds
are
good.
Okay, skipping over defaults for publication. That will be tabled until the July 30th meeting. Is there any other business that anyone would like to propose at this time?
Yes, I have been hounded by certain attorneys in our office regarding this matter. So we've had an issue lately in several different courts where defendants' motions to open have been granted almost immediately upon filing without giving us a chance to respond. I'm sure Attorney Pocklington is familiar with this, but many times defendants file motions to open along with case flow requests, indicating that the plaintiff consents to the case flow request, when in reality they haven't contacted our office at all with regards to the motion, and then the motion ends up getting granted the same day it's filed without giving us an opportunity to respond. I know specifically recently in Hartford, we've been getting emails from the clerk when motions are filed asking us to file an objection within a day or two or respond to them with regards to whether we consent or not, which I greatly appreciate. But I know some courts were having issues where literally within an hour of the defendant filing a motion to open, it gets granted without anyone reaching out to our office or obtaining a position. So by the time we know that the motion's even been filed, it's already been granted by the court, which is leading to some precarious situations with our clients where they're asking us why we didn't object at a hearing or file a written objection, and we have to tell them we didn't even know that the motion was being ruled upon, let alone having been filed. So that's something that I've been asked to just bring to the committee's attention. I know that, like I said, in Hartford, we've been getting emails from the clerk, and I'm sure Judge Bayo is aware of this as well. But I believe at least one case in Hartford, we did have a motion that was filed by the defendant. Our client did want us to object, but the motion was granted before we had an opportunity to object. So that's something I just wanted to bring to the committee's attention. I don't know if Attorney Pocklington has any input on this as well, but it has happened several times recently. It hadn't been an issue until probably the last several months, but I think it's been on the rise recently.
To echo a little bit of what Attorney Generous is saying, but also just give a sort of my perspective on the issue in general. Use of case flow requests in the modern COVID era is something that I know the plaintiff bar is more or less responsible for in terms of all the motions to open that were being filed during the period where non-critical court action was suspended and we needed to take appropriate steps to ensure that those motions were adjudicated timely. It does strike a little different when it's a homeowner. The one thing I will take a step back and say is when the lender is the one seeking to extend a sale or vesting, it's usually a safe assumption. Yes, to Jeff's point earlier about anecdotes and whatnot, I know we've all had one or two files over the years where a homeowner said, no, I really want this over and done with. I want the sale to happen. I want title to vest. But those are the extreme outlier cases from my experience, such that I feel comfortable saying that when the lender is the one asking for a sale to be postponed or a vesting to be postponed, that it's generally something that is in the interest of all of the parties, as opposed to when a homeowner asks, it is the odds of it being opposed or harmful to another party is significantly higher. I don't necessarily know where that takes us in terms of ensuring that appropriate opportunities for either opposition papers or hearings on opposition, be available, but just in terms of I don't want there to be seen to be a false equivalency. God knows I've done more than my fair share of Friday afternoon at 4 o'clock motions to open with case flow requests to push back a sale, but that's usually because it's ultimately sourced from something that a homeowner is trying to do with the lender. So they're not gonna oppose that they in fact usually want it. The reverse is not always the case.
And to be clear, I just want to point out that these aren't motions that are filed the day before the sale or the day before the law day. These are filed well in advance of the sale or the law day, but for some reason they're just being granted immediately and we aren't being a chance to respond. So I understand completely the situation where there's a sale at noon on a Saturday and a defendant files a motion at 3:55 on a Friday. But these are situations where it's up to a week prior to the sale and the motion is still being granted without a chance to respond. So, I mean, I would be fine with giving a day for the plaintiff to respond or scheduling a remote hearing. We're more than capable of attending remote hearings on defendants' motions to open if that's how the court wishes to proceed. But just giving some amount of time to reach out to our client and get a response and file an objection if necessary would definitely be appreciated. Just if only on a purely selfish standpoint of our clients getting mad at us when motions are granted without us having filed a response. So I just wanted to make it clear this wasn't a situation where it was an emergency motion to open filed just prior to a sale or something like that. And I would 100% agree with Attorney Pocklington about plaintiff filing motions to open with case flow request asking that sales or law days be extended based on loss mitigation or something trying to be worked out with homeowners. We do that quite frequently, and that was in fact what I brought up to my colleagues when they raised this issue about having hearings on defendants' motions to open. I was like, well, based on that logic, we should have a hearing every time we file a motion to open as well. But I would agree that probably 90% of the time those motions are beneficial to the homeowner as well. And they have no objection whatsoever to us extending them. I have had the rare situation where a defendant does want a sale to go forward and our client is doing something internally and they've asked us to place the file on hold and extend the sale date. But that is very, very rare. So I just wanted to clarify what I was saying with regards to the timing of these motions.
I don't know if that requires any business by the committee, but I can tell you this, I will have some discussions, just when I run into my colleagues in different districts, just to be aware of that issue.
I think we all have we all have varying levels of confidence when a self-represented party checks the box of consent. It's some of us are like, I'm not sure I'm going to take that to the bank. And others of us may be more trusting and say, well, if they check consent, that must be so we don't need to talk to anybody. But if you've been burned, I would suggest if you have a way, the next time you're in that judge's courtroom, virtually or in person, just say, Your Honor, I'd just like to bring to your attention that, because, or that when you go in, you got to refile your motion for summary judgment, your motion for judgment, right? Because the sale was vacated by the judge?
Or it might have
No,
just been
these are generally
extended.
just extensions of the sale date.
Well, yeah, I know. So if it's extended, you got to go back and reset or is it just reset? You
No,
never even
the
get a
court
chance-
is just setting a new sale date.
Oh, okay. You don't even get a chance to say hello.
No, but that's the
That-
problem. We don't get any opportunity to address it at all. So
Well, then
that's
I
really the
would
issue
file
that
a
we're
case
having.
flow request, just noting the fact that the defendant wrongfully misrepresented that you had consented to that. So at least maybe you could hit the judge over the head.
And guys, is this just a self-rep issue? Or are you getting it in
Yeah.
other cases as well?
It's mostly just a self-represented defendant issue. And I mean, it's no fault of the defendant. The defendant's filing a motion asking for additional time. They're filing a case for request, asking the court to rule on the motion. The issue isn't so much that with anything that the defendant is doing, it's just that the court is acting on the motion without giving us an opportunity to respond to it. So I have no issue with the court taking the papers on the motion, as long as we have an opportunity to file an objection if necessary. If not, we can certainly notify the court there's no objection to this motion. Occasionally, defendants will file motions prior to us filing a motion to extend when there's a trial plan in place or something like that, because occasionally our clients will be a little delayed in giving us instructions to postpone the sale, so the defendant will file their own motion, and I have no issue with that. It's just an issue of opportunity to respond and object if necessary.
Got it. That makes sense. Maybe it's like I don't know, 2 business days. This is like sort of be the buffer, like a whether it's a best practice or not for courts to just wait before they grant off that kind of representation. But that sounds like I didn't want to misrepresent what you said, but it sounded like that
Yeah.
sounded
And I
roughly
think that's what
enough.
Hartford's doing. It looks like usually when we get an email from them, they give us about 2 business days to file an objection. If nothing's filed, the court is obviously going to rule on the motion. We have no issue with that.
Yeah.
And we do appreciate the heads up, because sometimes we don't even get a copy of the motion until 2 days after it's filed, and it's granted a day after it's filed, and we didn't even know it was filed at that point. So especially when defendants are filing like handwritten motions to open, they go to the clerk's office and file. Sometimes it takes a while to get scanned in. We can't see it. We don't see what the substance of the motion is.
No, and I imagine you're not always getting e-service either.
Thank you for your offer to talk about it with your peers, Judge Spader. I think ultimately this may be here's the thing, I see it too. The ones that always sort of get my goat a little bit are the ones that are filed with a fee waiver, where the fee waiver and the form motion to open that gets scanned into the file and thus made available for review already have the judge's signature on them, as in they were taken to the judge, acted on, and then processed. And those are outliers by any stretch, but they happen often enough that angry clients, as George has mentioned, are not something that any of us on the plaintiff side are unfamiliar with. But it is it is what it is. I don't necessarily think that this is a committee fix issue, but it is something that I appreciate the forum to raise, knowing that it'll get raised with, impacted individuals. So thank you.
Certainly, and I don't know what the source of the issue is. I don't know if it's that someone in a clerk's office is bringing a motion to a judge, they see the consent box, they say, okay, this was consented to by the plaintiff, and then the judge isn't aware that it was even a situation where we weren't given the opportunity to respond. So I do appreciate Judge Spader saying that he'll speak to his colleagues about this. I think if everyone is just more aware of the situation and of what's going on, then we can clearly avoid it. And like I said, I don't know at what level this is happening. I don't know if it's an issue with motions being brought to the judge without actually determining whether or not the plaintiff consents to the motion or not, or if it's I don't know. I frankly have no idea. So I would agree that I don't know that there's necessarily something that can be done apart from some kind of standing order, which I don't think Judge Bellis would be inclined to agree to. But as long as this can be brought to the attention of the judges, that would be very helpful.
Is everyone okay with where that one landed? And we'll just make a notation of it for today's meeting, and it will not be on the next agenda.
Yes.
I don't know if Judge Bellis will have any input just based on or Judge Bayo will have any input just based on what they've been doing in Hartford. She may have some input. So if we want to just briefly touch on it when she is here. But other than that, I don't think we need to raise it again.
Do you prefer to have it just on as new business for the next time so she can be briefed on it, or?
That would be fine.
Okay, that's what we'll do. We'll add the issue of defendant's motions to open being looked at upon consent of a case. So I can, just from the clerk's office perspective, I can weigh in and tell you that the clerk is never going to check for whether or not there is true consent. We're gonna believe, and people do misrepresent in family and civil and housing and all aspects of court, whether or not there is true consent. I would be, interested if upon further reflection, there was any issue in the clerk's process. I would have a feeling that the clerk's office is reaching out from Hartford because they're being directed to ask the question by the judge. If a judge asked me to find out, I would absolutely, as a clerk, find out.
And that's why I was just asking for
Yeah.
Judge Bayo's input, because I have a strong suspicion that she may be involved in this process.
Yeah.
And it is because it is tricky as well, because technically the case flow request is just asking for the motion to be heard, which is fine. We would consent to that. We have no problem with the motion, the underlying motion being heard. It's just taking it a step farther somehow than that we consent to the motion and the motion is just being granted. So if the court wants to order hearings on all of these, we have no issue with that. We'll attend the hearings and we can address it at that point. It's just I think a little bit of a misconception on the form where it's just checking consent to the case flow request and not the actual underlying motion.
So I will go ahead for the July agenda and add that under new business, just so that Judge Bayo can be, briefed and offer any thoughts she has. Any other business? Judge Bayo did ask me to let you all know that if anything comes up between now and July that you think would be something that this committee should consider, to just reach out and let us know, and she can have it added to the agenda in advance of the July meeting. Next meeting is July 30th at 3:30, again via Teams. So it'll be midsummer before we see you all again. That being said, do I have a motion to adjourn?
So moved.
A second?
Second.
Second.
Thank you. Connor, all those in favor?
Aye.
Aye. Thank you everyone for bearing with me, and we'll see you all next time.
Good
Thank
job,
you.
Beck.
Wonderful day, everyone.
Thank you.